New York's real estate commission rules and regulations form the backbone of property transactions in the state. Understanding these rules is essential for brokers, agents, buyers, and sellers alike. In New York, real estate brokers must be licensed to operate legally. This involves completing pre-licensing education, passing a state exam, and meeting experience requirements. Brokers must also adhere to strict ethical guidelines and regularly renew their licenses through continuing education. When it comes to commission disputes, only licensed brokers can sue for real estate commissions. Real estate agents and salespersons cannot sue for commissions unless the broker specifically assigns them the right to do so. This is a critical distinction in New York real estate law. The appropriate remedy used in real estate commission disputes is typically summary judgment. For this to succeed, the broker must provide legally sufficient proof of entitlement to the commission. Courts require clear evidence that the broker's efforts were instrumental in completing the transaction. An employment contract between a broker and property owner is established when the owner lists their property with the broker, who then works to find suitable buyers or tenants. According to New York law, if a broker's services are used without limitations on commission, they are entitled to payment when they provide a qualified buyer or tenant ready to complete the transaction. Importantly, brokers earn commissions only when they arrange a successful transaction. Simply introducing prospects or showing properties is not enough to warrant commission payment. The transaction must be completed for the commission to be earned. Commission structures in New York typically range from 5 to 6% of the final sale price, though rates can vary. These commissions are influenced by factors such as transaction complexity, market conditions, service level, and whether the broker represents both parties. Commissions are usually split between the listing broker and the buyer's broker. While written commission agreements are not legally required in New York, they are strongly recommended. Licensed real estate professionals are exempted from having written agreements under General Obligations Law, Section 5701. However, formal agreements provide clarity by detailing commission rates, services provided, agreement duration, and conditions for earning the commission. Broker agreements come in several forms. Exclusive right-to-sell agreements entitle the broker to a commission, even if the seller finds a buyer independently. Exclusive agency agreements only pay the broker if they secure a buyer. Open listings allow sellers to work with multiple brokers, with only the one who finalizes the deal receiving payment. In some cases, brokers can claim commission based on implied contracts, even without formal agreements. Courts may recognize an implied agreement if the broker provided significant services, the property owner benefited from those services, and there was a reasonable expectation of payment. However, proving entitlement without a formal agreement can be challenging. If an agreement doesn't specify the commission amount, the broker is entitled to fair and reasonable compensation for their work. Many brokers now negotiate tiered commission structures, earning higher percentages if they exceed target sale prices. Recent legal updates in New York emphasize transparency in commission structures. Brokers must clearly outline their fees, ensuring clients understand how commissions are structured and paid. These changes aim to protect all parties involved in real estate transactions. Understanding New York's real estate commission rules helps prevent disputes and ensures fair compensation for services rendered. Whether you're a broker, agent, buyer, or seller, knowing these regulations is essential for navigating property transactions successfully in the Empire State.